Thank you, Mr. Chairman, and thank you to the witnesses for being here today. I want to follow up on a point that Mr. Scott raised today regarding what really is a crisis at the NLRB, which is that we have a newly confirmed member who, again, was sanctioned by not just the Inspector General, but the Ethics Office in terms of participation in the Browning-Ferris decision. And again, this, I think, screams out for a hearing by this subcommittee, given the fact that not only was these findings made, this is not a settled matter. Mr. Emanuel's lawyer has communicated to Congress that he basically rejects the opinions of the Ethics Office and the Inspector General, and it continues to insist that he has the right to vote on matters that he handled or his law firm handled prior to his holding office. This is like having a member of Congress saying that they willfully refuse to accept a decision by the Ethics Office. I served on the Ethics Committee for 2 years, and we have various sanctions in terms, and it was bipartisan. In fact, it's totally nonpartisan. There's no majority on that committee. And to allow a state of affairs to continue to exist at the National Labor Relations Board, again, Dr. LaFaso, having been, somebody who was proximate to the way the board operates, I mean, this is a real problem in terms of just the functioning of the board.
Yes, I want to limit my comments to saying that I don't know about his specific situation, and so I'm going to say it hypothetically. But let's say everything you said is absolutely an accurate description of what is going on. The problem is that the people, the Inspector General and the ethics officers, these are people that are, and people who work on these things are generally career employees who are not, they're not trying to be political. If anything, what they're trying to do is maintain the integrity of government, which is one of the most important things to keep our faith in government and the public faith in government. So it's very important that what we understand is that if you have an ethics decision that is disfavorable to an employee of that agency, you have to understand is that in general, they're looking for any way they can to say this was ethical. And so I would say that there's a lot of weight behind that, and that for someone to then say, I'm not going to listen to that, I think creates like the equivalent of a constitutional crisis, but within the agency. Right. So it's something I think that we have to take really seriously and try to understand. Now, of course, if there really is something wrong where the ethics people are going wild and saying this is wrong, then also you should get to know that too. So a hearing could vindicate him.
Right, and again, a hearing, which I think is obvious for this subcommittee to hold, is really, as I said, it sort of screams out for it. Someone who practiced law for 27 years before having the honor of representing Connecticut's 2nd District, one of the things we did in our law firm, anytime a new client was coming in, is you kind of just ran the traps in terms of making sure that there was no conflicts. I mean, this extends beyond, serving in a public agency like NLRB. I mean, it's really sort of boilerplate rules that attorneys have to follow as a matter of course, or you would be subject to ethics sanctions by the state grievance committee.
Or
also,
the
Doctor,
appearance of
if I could just follow up real quick on,
Sorry.
We've heard a lot about card check as somehow that this is sort of ramming over people's rights. Again, this has been part of the law since 1935. The Supreme Court has actually had a number of cases where individuals like Mr. Bowman have challenged whether or not this somehow usurps people's rights by providing an avenue of recognition that through the card check process. Every single instance, the Supreme Court has upheld that provision of the law. Earl Warren, appointee of Dwight Eisenhower, wrote one of those decisions. Again, just real quick, I mean, we're not talking about something that's really been ever challenged as somehow depriving individual workers of their rights. Is that correct?
That's correct. It's well developed in the jurisprudence. Gissel is the main Supreme Court case from 1969.